I'm Maclin Davis, one of the oldest lawyers in Nashville, where I've been practicing law since March 1950. And during that time, my 58 years of being a lawyer, I have noticed tremendous changes in the rulings by courts on the meaning of the United States Constitution. And when I went to school, from grammar school through prep school at MBA and college at VMI, North Carolina, Columbia, and Vanderbilt, they taught history, American history courses that contained much of what I'm going to talk about today. And people old as I am would probably remember this, what I'm saying, from their education, but the schools no longer teach these things in American history. And I think that's a big mistake that the schools make today. And that's, I think, from grammar school through high schools through colleges, even law schools. So anyway, this speech is about the United States Constitution and its history and how it's supposed to be considered and construed. On July 4, 1776, the 13 American colonies adopted the Declaration of Independence, declaring that they were free and independent states with no longer any allegiance to Great Britain. In this declaration, they stated that all rights inherently belong to the people, and government has no just powers except those given to the government by the consent of the people who are to be governed. Thereafter, the War of Independence began, and the colonies defeated the armies of Great Britain in 1780. In the Declaration of Independence, the colonies stated that they should be free and independent states with the right to do all acts which independent states may do. On September 17, 1787, after almost 4 months of meeting at Independence Hall in Philadelphia, delegates from the states created the Constitution of the United States. Article 7 of the Constitution provided that it would be established by the ratification of the conventions by 9 of the states ratifying it. Thereafter, the first 10 amendments to the Constitution were drafted because some of the states were unwilling to ratify the Constitution without those 10 amendments, which were called the Bill of Rights. Those 10 amendments and the Constitution were ratified by all states, effective December 15, 1791. The most discussed provision in the Constitution today is the First Amendment. And today it is usually misconstrued because people don't read it. That amendment does not give any rights to people, since the people already had all rights that were not given to the government in the Constitution. The first word in the First Amendment is Congress, and the First Amendment is a list of specific laws that Congress shall not make. This is made absolutely certain by the 10th Amendment, which expressly provides that the powers not delegated to the United States by the Constitution are reserved to the states or to the people. The Constitution is a written document consented to by the people and worded so as to establish a government by consent of the governed and a government of laws and not men. It was clearly the intention of the people who ratified the Constitution that the original meanings in the Constitution could be changed only through the amendment process, by which amendments are consented to by the governed. The people have never consented to judges having the power to change the meaning of the Constitution from its original meaning. If that is allowed, then the government is no longer a government by consent of the governed and becomes a government of men, not laws. If judges are allowed to bring about changes in the Constitution after the governed people have consented to the written Constitution, then the Constitution means only what current judges say it means, and not what it meant at the time the governed people consented to it. And the meaning could later be changed at any time by the same judges or subsequent judges without ever obtaining the consent of the governed.